We start off, we've got two cases, correct?
Correct, Your Honor. Both.
And you are Caleb Landry?
Sir.
In 23 CR 908, the earlier case, you were charged with the state jail felony of burglary of a habitation on or about February 14th, 2023. And that carries with it no less than 180 days up to 2 years in the state jail. You'll understand if convicted.
I think you said burglary of a habitation.
I said burglary of a building, state jail, a burglary of a building, not a habitation, a burglary of a building, which is lesser than a burglary of the habitation. It's no less than 180 days up to 2 years in the state jail. Burglary of habitation is a second degree felony. Do you understand what you're charged with here in this?
Yes.
And in 24 CR 2225, filed on October 23rd of last year, this states that on September 17th, 2024, that you committed the state jail felony of burglary of a building. It's like the same building owner. The victim is the same as the previous case.
Probably discount tires, right?
And it goes on to state that you have, in this indictment, you've been convicted in 2005, felony.
All right, folks, buckle up. 2 felony charges, 1 defendant, and a whole lot of legal drama about to unfold. This isn't just a case hearing. It's a lesson in how your past can follow you like a shadow in the courtroom.
Offense of illegal possession of marijuana, a state jail felony out of Harris County, Texas. And in 2015, you were finally convicted in the criminal district court here of delivery of marijuana. And that doesn't affect the punishment range on this, does it?
Yes,
Judge. If he's
Two prior state jail felonies on separate.
Makes it a third.
Makes it a third degree.
Well, your punishment range is in two things that are problematic. Your punishment range will be enhanced if this is proven true to what would be a third degree felony punishment. It's state jail felony, but it's punished as though it was a third degree felony under law. And you were looking therefore at no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed.
Notice that prior convictions are being rolled out like a criminal resume. This isn't just background noise, it's critical. In Texas, prior state jail felonies can enhance future punishments, pushing a simple burglary into third-degree felony territory. Think of it as a legal snowball effect.
Plus, if this is true, you are not eligible for probation in either of these cases. Do you understand?
Sure.
Okay, that's should be a lot on your mind here. What are we going to do today?
Your Honor, the state has tendered an offer of 12 months or 1 year in the state jail facility. And
how much time does he have credit, if any? Please. Okay, go ahead.
And Mr. Landry's advised that he's refusing that. Is that correct?
Okay.
That's
what you want to do?
The state's offer.
That's what you want to do?
Because
it's a hard decisions, but it's your life. Right now we're at a crossroads. It's either going to go that way or this way. Which one?
To be clear, one thing that hasn't been stated, he is not eligible to receive probation from a jury.
I said that.
Should he do that, I will, if he continues down that path, I'll withdraw the state jail offer and give the enhancement notice on both cases, so that they're both dealing with third degree. Sure.
Okay, it wasn't.
It wasn't included in the first indictment for some reason. We must have recovered them, but by the time he alleged to have committed the second offense.
He has 17 days credit.
Yeah, not a lot.
not a lot.
Let me ask something here. What's his bond?
What are your bonds?
$5,000
each. Yeah. Probably 5 each, Your Honor. That's what he seems to.
He's correct.
Okay. When was this bond posted? In 908. I'm looking at July 15th of 2024, correct? Is that right, everybody? That's what I'm seeing.
If that's right, then
It's $5,000
he's alleged to have committed the second offense while he was
in
on bond.
September.
Pause right here. Did you catch that? If this enhancement sticks, he's looking at 2 to 10 years and 0 eligibility for probation. In legal terms, that's the system saying we've given chances. This time we're serious.
Yeah, we got a bond issue. You committed, according to the grand jury, and this second offense after you had been charged and in this earlier case, and you posted a bond of $5,000. Let's see, stand by. Looks like the amount of bond was fixed at $25,000 on July. I'm looking at another document that says July 20th.
You made the accusation may have run, the initial arraignment may have been 20. I'm sorry.
There's a 715, a $5,000 on 7 that he paid on 715. But then there's a warrant for an arrest, a capious burglary of a building filed on July 16th. Okay. And the bond was fixed. Who's selling this?
He probably got
Says the amount of bond fixed by the court in this case is $25,000 here.
that was probably the initial arraignment. He didn't post bond.
Yeah, it was an arraignment.
And he got out on accusation after that, and the warrant popped up sometime after he was released on accusation in the bond.
But it's showing
On the warrant,
5,000.
was set at 5.
Is that right, Lacey? It's showing 5,000 on this? Okay.
But he was arrested on.
Here's where the timeline tightens like a noose. He was already out on bond for one case, and then allegedly commits the same crime again. Same building owner, same charge. This isn't coincidence. It's a prosecutor's dream and a defendant's nightmare.
And all of this was done, though, before it is alleged that he commits this next crime, 24 CR 2225.
He may have been out on the accusation on the second offense.
No, the second offense is on or about September 17th of 2024. All of this is July. And July.
It's the initial bond he made in 908. It was made on 7/15 of 24.
Yes. Of
$5,000.
yes. Then what?
And then it looks like the bondsman surrendered that bond when he was rearrested. And he made another bond in this case on 2/10 of 25.
Of how much?
The initial bond was
No, I'm talking about the new bond.
Should have been 10 if there was an airport.
It wasn't an AFRS, it was a surrender.
Oh, all right.
Is it showing it's still 5,000? Yes.
Yes,
Okay.
still 5,000.
Okay. And then when did he post the bond in 24, 22, 25? The new code.
10 of 25,
What was that bond?
5,000.
Yes. Well, on what day now?
2/10 of 25.
Okay.
That's after the.
Yeah. That indictment had already been prepared and has those prior convictions, and then you have that.
Right.
It just slipped. It must have slipped by somebody. See, on this indictment, here's what's once again, I don't know how this is happening. On this indictment, on the face of the indictment, 7/20/23, that's me writing it. When I get the bond, I'm setting the bond at $25,000 plus a GPS device. Do you even have a GPS device? You don't even have that. I don't know what are my orders doing here that aren't being followed. I don't understand. But this was my orders on July 20th of 2023. Thereafter, those are changed. Or
I represent the court. I didn't have anything to do with it.
you didn't. Yeah, you're always the first suspect, but you've been cleared in this
I would
one.
like to take credit.
Anyway,
I don't have any notes to explain, Judge.
those were being changed without, and this court had authority over this case, and somebody else was changing these.
It was post-indictment, yeah.
It was post indictment after I had signed these orders, which are equivalent to an order, which is inappropriate, but we'll figure it out. Anyway, this court doesn't find $5,000. I mean, I put $25,000 up here, but I did this before this indictment shows up.
Right.
And then this indictment shows up, another burglary of a building, which is alleged to have occurred on or about September 17th of 2024, after he was on bond here. Your bond's $100,000 in each case. Plus, you have to have a GPS device as a condition of bond. So this is irresponsible and of your part. And once you are charged with a crime and a bond is set, and you're presumed innocent unless found guilty. But these are probable cause decisions by the grand jury that you probably committed these crimes, which are what we base bonds on, as the probability a crime has been committed. And we use the circumstances of the case and the criminal history. Your first bond of $5,000 is the same type of offense that you post a bond. A few months later, you're committing another of the same offense, the same type of offense, as though.
Now hold up, bond confusion, missing GPS orders, overlapping dates. Sounds like administrative chaos behind the scenes. But chaos doesn't help the defendant. Judges hate it when orders are ignored. Expect the hammer to come down hard.
None of this mattered to you. You weren't taking it seriously. You are now. We're going to take it seriously. You can't just keep committing crimes and think that you can just pay a small bond and not that additional information and additional crime commission won't have a bearing on it. It does. So those are the orders. You must have a GPS device, and the bonds are amended to $100,000 each because of your criminal history and the fact that you're committing the same crime after you posted a bond in the first case of a similar matter. Just a few months after that, you're committing the same kind of crime, according to the grand jury. Anyway, that's the orders of the court. Next event, you set these for trial. It'll be set for trial. Thank you. That's what we'll do.
Boom. There it is. Bonds raised to $100,000 each and GPS tracking slapped on. Why? Because the court sees this not as a misunderstanding, but a pattern. And in the justice system, pattern equals intent. Audience, let me ask you, should bond be low if you repeat the crime while already on bond?